Right, go ahead, Kara. All right, welcome to today's program representing UN employees in their family law disputes. This program is organized by the New York State Bar Association International Section's Family Law Committee. Richard Min, who is also here with me today, and I co-chair that committee and are grateful to include you in this wonderful and informative webinar, particularly for those who practice family law in New York, but even for family lawyers throughout the world. You may encounter a client who is employed by an international organization. One such international organization is clearly the United Nations. The UN provides its employees with technical benefits packages. They have different tax obligations. There's complicated rules related to their pensions. There's even issues of privileges and immunities. Our panelists, staff at the United Nations, will share information about the UN structure and the issues its employees face when dealing with their private legal obligations. During the program, please post your questions in the Q&A. I will be monitoring the questions and we will do our best to answer what we can at the end of the presentation. And I am going to now turn over the program to Catherine Alford to introduce herself and her co-panelists and get us started.
Thank you very much, Melissa, and for that introduction. And thank you very much, Melissa and Richard, for inviting us to speak to the panel and to the group today, and Kara for facilitating this. This is, I suppose, why we here today. We were asked to speak about the United Nations and staff members and their private legal obligations. The United Nations can seem quite impenetrable and a little bit distant, but we hope today's talk is informative and interesting, and to dispel some of those maybe impenetrable kind of images that you have. Most of the information we'll tell you about today, it's online. We're trying to make more and more available, and hopefully it will all be clear to you in terms of the legal framework of the United Nations today. You can relax. I understand the presentation will be provided to you, perhaps if it's not already provided to you at the end. It has a list of resources that we will be talking about today, so you have all that available. So just by way of introduction, my name's Catherine Alford. I'm the Director of the General Legal Division in the Office of Legal Affairs here in New York. And I'm joined by two of my colleagues in the Office of Legal Affairs, Mr. John Stomper, who's a Senior Legal Officer, and Miss Francisca Lagos-Pola, who's a Legal Officer in my division. I'm also very lucky to be joined by three other colleagues, Ms. Erin Thomas, who's the Chief of the Specialized Advisory Unit in the Human Resources Division in the Department of Operational Support, and Ms. Dulcie Mapandera, who's the Chief of the Legal Office in the United Nations Joint Staff Pension Fund, and Mr. Cristiano Papile, a Legal Officer in the Legal Office of the United Nations Joint Staff Pension Fund. We have really long titles in our names, and we have a lot of acronyms. We'll try and dispel some of the confusion here today. And I am obliged just to say that the views expressed here today by myself and my colleagues are those of me and my colleagues, and do not necessarily reflect the views of the United Nations. Thank you. So, John, if you wouldn't mind going to the next slide, please. I would like to just provide an overview of the presentation. So John, Francisca, and myself, we're from the United Nations Office of Legal Affairs, specifically the General Legal Division, which deals with the matters with our colleagues in this room, in this virtual room, on these private legal obligations. Francisca and I today will try and explain to you, I mean, you're all familiar with the United Nations, but explain a little bit more about at high level what the United Nations is. And then we'll introduce the legal framework at a very general and high level, touch on the privileges and immunities of the organization, the United Nations, and also touch on staff members' obligations to abide by their private legal obligations, including paying family and child support. I will then pass to Erin, who will deal with the legal framework and how the United Nations Secretariat processes third-party claims for spousal or family support. Erin is a real expert in this area and will get into a lot of the detail. There will be a lot of information that you'll hear today. Hopefully you might absorb some of it, but as I said at the end, you will have the resources available as well. And also very lucky to be joined by my colleagues Dulcie and Cristiano, who are from the United Nations Joint Staff Pension Fund, which is a subsidiary organ of the General Assembly, and they will explain the legal framework, which is different, additional in they have the pension fund has an additional legal framework, and explain how the pension fund processes third-party claims and spousal benefits. So if I can move on to the next slide. The picture is probably familiar to you, the United Nations Secretariat building where a few of us work. We have other offices scattered around the New York City area. But as you know, the United Nations is an international intergovernmental organization. It's composed of 193 member states. It has the presence here in New York, which is the New York headquarters, but it also has a global presence with tens of thousands of employees. We have regional commissions, offices away from headquarters in Nairobi, Geneva, Vienna. We have regional commissions across the globe, and the Office of Legal Affairs supports, and my colleagues support all of those. The United Nations was established by the Charter of the United Nations that was signed on 26 June 1945 in San Francisco at the conclusion of the UN Conference on International Organization. As you know, it was founded after World War II to save succeeding generations from the scourge of war. It's a mandate that my colleagues and I are very happy to walk to every day to come to work to try and support. The purpose of the United Nations, that comes from Chapter 1, Article 1 of the Charter of the United Nations. And here you'll see it's to maintain international peace and security, develop friendly relations among nations, achieve international cooperation in solving international problems, promotion of human rights and international law, and to promote social progress and better standards of life. And we need staff members to actually implement those activities. And as I said, they have a presence globally. Just at the very high level, the United Nations principal organs, there are 6, and it's set out, if you have the time and the interest, to have a look at the Charter of the United Nations. First of all, you're very familiar with the United Nations General Assembly. For those of you who live in New York, it's often a little bit of a challenge in 1 week in September, when there's a high level week when VIPs, presidents and prime ministers and very high level officials gather for the high level week in New York. But just a little bit of history, in 1951, there were originally 51 member states. That has now ballooned to 193 member states, of which the United States of America is one. And in 2011, the most recent member was South Sudan, and they were admitted on 14 July 2011. Moving on to the Security Council, we'd be very familiar with that, very much in the news. As 15 members and 5 permanent members. The People's Republic of China, France, the Russian Federation, the United Kingdom of Great Britain and Northern Ireland, and the USA. There is also, third, the Economic and Social Council, the Trusteeship Council, the International Court of Justice, and the 6th is the Secretariat. And this is where John, Francisca, Aaron, and I work in the Secretariat, and our colleagues work in the UN Joint Staff Pension Fund. There are various offices in the Secretariat, and the Office of Legal Affairs is one, as is the Department of Operational Support where Aaron works. The General Assembly can also establish subsidiary organs under Article 22 of the Charter, and this is where we come to the United Nations Joint Staff Pension Fund, which is one such organization. Other examples are UNICEF, UNDP, UNFPA, UN Women, etc. And the United Nations system, which is often a term that you may hear, includes the United Nations, its principal and subsidiary organs, specialized agencies, and also agencies brought into a relationship with the United Nations. We'll be talking about the United Nations here today. So for my last slide, just a little bit about the Secretariat and the Secretary General of the United Nations. The Secretariat is really the operational arm of the United Nations. This is where we get things done, make things happen. We have the mandated and programmed activities of the United Nations, and we're here to support the Secretary General in his work as Chief Administrative Officer of the organization. The Secretary General, currently Antonio Guterres, is established under Article 97 of the Charter of the United Nations. He is appointed by the General Assembly upon recommendation of the Security Council, which we just spoke about. The staff of the United Nations under the Charter shall be appointed by the Secretary General under staff regulations established by the General Assembly. And you can look to Article 101 of the Charter to see that. And this is where we start getting into the legal framework with the Charter and the staff regulations and other issuances that we'll talk about. So as I said, the staff members of the United Nations are appointed to perform the mandated activities of the United Nations. I will stop here, and it's my pleasure now to hand over to Francisca to introduce the legal framework. Thank you.
Thanks, Catherine. So now we will turn to the legal framework of the United Nations, and we'll look at the implications of this legal framework on the private legal obligations of staff members, including their obligations to abide by family and child support court orders. The legal framework is important as it gives background on how the organization addresses family and child support court orders. So we will be looking at 5 documents. They are the Charter of the United Nations, the Convention on Privileges and Immunities, the Staff Regulations and Rules, the Secretary General's Bulletin on Family and Child Support Obligations of Staff Members, and lastly, the Administrative Instruction on Private Legal Obligations of Staff Members. Now, the first 2 documents are international treaties, and as such, all countries that have ratified them are bound by their provisions. The last 3 documents are internal policies of the UN, which means that UN staff members are bound by their provisions. Next slide, John, please. So the first document we will look at is the United Nations Charter. As I mentioned earlier, it is an international treaty. And so that means that the countries that have ratified the Charter, including the United States, are bound by it. The United Nations Charter is the founding document of the United Nations. It was signed in San Francisco on the 26th of June, 1945 by 50 countries and came into force on the 24th of October, 1945. The UN Charter codifies the major principles of international relations, from sovereign equality of states to the prohibition of the use of force in international relations. It also importantly codifies in Article 104 the legal personality of the UN. This article ensures that countries that have ratified the Charter recognize the legal personality of the UN so that the UN is able to carry out its functions in the countries in which it operates. The UN Charter further codifies Article 105, which states that the UN enjoys in the territory of each of its members such privileges and immunities that are necessary for the fulfillment of its purposes. Now we will look at the next document that talks more about the Convention on Privileges and Immunities. The Convention on Privileges and Immunities was adopted by the UN on the 13th of February, 1946, to give effect to the 2 provisions that we spoke about earlier, which are Article 104 of the Charter on the legal personality of the UN, and Article 105 on privileges and immunities of the UN. The convention was acceded to by the United States in 1970 in accordance with Article 6 of the Constitution of the United States. The convention provides in Article 2, Section 2, that the UN, its property and assets, enjoys immunity from legal process, except where the UN has expressly waived its immunity. That means that unless the UN has waived expressly its immunity, its property and assets are immune from legal process and are not subject to garnishment or attachment. This immunity extends to the salaries of UN staff members until the salaries have been paid. Practically speaking, what does this mean? This framework has significant implications when the UN receives a court order garnishing a UN staff member's salary. In such instances, this framework provides the UN with a right to assert its privileges and immunities in respect of that order. Having said that, the privileges and immunities set out in Article 2, Section 2 of the Convention belong to the UN as an organization, and do not relieve its employees of their obligation to satisfy their private legal obligations, which include abiding by family and child support court orders. Now, let's look more closely at the private legal obligations of staff members, which are set out in the internal policies that I mentioned earlier. Next slide, please, John. So the first of the internal policies are the United Nations Staff Regulations and Rules. The staff regulations and rules regulate the conditions of service and basic rights and obligations of UN staff members. They regulate a variety of matters, from the amount of leave that a staff member has annually to the responsibilities staff members have as international civil servants. So in Regulation 1.1F, it is established that the privileges and immunities of the organization do not relieve staff members of their responsibility to observe local laws and police regulations of the country in which they're located, or of their responsibility to comply with their private legal obligations. The obligation of staff members to abide by their private legal obligations is also reflected in Staff Rule 1.2b, which establishes that UN staff members have to comply with local laws and honor court orders. Practically speaking, this means that UN staff members have an obligation to abide by child and family support court orders and cannot hide behind the privileges and immunities of the United Nations. The UN also has the authority to make sure that staff members abide by their private legal obligations in the context of family and child support court orders through Staff Rule 3.16c. This rule contemplates that the UN, upon receipt of a final family or child support court order, will make deductions from a staff member's salary in respect of the amounts reflected in that court order. Now over to Erin, who will explain more about the internal policies of the UN and how the United Nations specifically addresses child and family support court orders against its staff members.
Thanks, Francesca. John, if we could have the next slide. Next in the hierarchy of the organization's administrative issuances are the Secretary General's bulletins, which are issued by the Secretary General, and administrative issuances or administrative instructions that are issued by the Undersecretaries General. And with respect to family and child support, there's two relevant issuances, and they're cited here on the slide. SGB 1999/4, which details the procedures the organization will follow upon receipt of a court order for support that's not being honored. And then Administrative Instruction 2000/12, which addresses procedures the organization will follow with respect to family and child support orders, as well as other private legal obligations. And the main difference between these two policies is that the organization will voluntarily garnish a staff member's salary to help secure compliance with the family support court order, but it'll not garnish salary for any other financial obligations. However, failure to honor these other private legal obligations may subject a staff member to disciplinary action under the organization's framework for unsatisfactory conduct. Next slide. When it comes to the administrative procedures, the first step is ensuring that the claim gets to the right department. As Catherine mentioned, we are a massive organization with tens of thousands of staff, and the correct entity is the entity that administers the individual staff member. Now, the claims from third parties alleging non-compliance are sometimes sent to a wide range of offices, departments, other entities, and if the recipient doesn't administer the individual, they will attempt to identify first whether the individual is actually a staff member of the organization, and then they will try to route that claim to the responsible entity. I will note that sometimes claims come in relating to former staff or individuals who had a non-staff engagement with the organization, perhaps as a consultant or contractor, or who work for other UN entities like Catherine mentioned. And some claims also relate to people who we have absolutely no record of. So if the individual is not a current staff member of the United Nations Secretariat, we're limited in our actions. It's generally recommended that the recipient be notified that the individual is not a current staff member. And if there is contact information for the individual, it's recommended that the claim be forwarded to them with a request to resolve the matter. However, if the claim does relate to a current staff member, once the responsible entity has the claim in hand, if it appears to be a final order, they will inform the staff member and request that they comply with the order and submit proof of that compliance within 30 days. Now, for purposes of our policies, a court order is deemed final if the only action left in regard of that order is to have it executed. And in practice, as support orders concern the ongoing maintenance obligations, the fact that a staff member is appealing a process doesn't necessarily preclude enforcement unless the staff member provides proof that the order has been stayed or is not executable in the relevant jurisdiction, because as you know, every jurisdiction has wildly varying rules. If we could go to the next slide, John. As I noted in the previous slide, the staff member has 30 days in which to respond, and the subsequent actions will depend on the nature of the staff member's response. Generally, if they provide proof that they are complying with the court order, the matter will be closed. Likewise, if they provide proof that the order has been set aside, vacated, stayed, or that they've otherwise amicably resolved the matter, then the matter can be closed. It's not mentioned on the slide, but sometimes questions arise about the status of the order. And in those cases, the entity may reach out to the permanent mission of the United Nations of the relevant member state for clarification or confirmation, as we are not legal experts in family matter jurisdictions of every member state. Now, finally, if the staff member doesn't provide satisfactory proof of one of the above, the administration will commence the internal approval process for deductions. Go to the next slide. And before we go on, I just want to flag an important caveat about support orders that's relevant to practitioners. You'll often see court orders establishing an ongoing monthly support amount, as well as an amount of overdue support or arrears. And at the outset, I mentioned the difference between family and child support obligations and other private legal obligations. And the issue of arrears is where the distinction between the bulletin and the instruction is key. Because if a court order also includes an order for monthly payments specifically for the purpose of liquidating judicially established arrears, then the organization can include those payments in the deductions that may be made under the bulletin. However, if the court order simply orders payment of arrears in a lump sum or establishes an amount due without a monthly liquidation payment, the instruction, not the bulletin, implies, and the organization is not able to make deductions to liquidate those arrears. However, the staff member will still be asked to resolve that matter, and failure to provide proof that they have liquidated the arrear or that they've provided for the ordered arrears, again, may constitute unsatisfactory conduct under the organization's framework and may lead to disciplinary measures. We could go to the next slide. So far we've been talking about the receipt of court orders, which are often sent to the organization directly by the ex-spouse of the staff member or the attorney. However, in some jurisdictions, and I think including New York, child support enforcement agencies may issue notices or income withholding orders, which instruct the employer to take action to garnish an employee's wages. Additionally, in some protracted disputes, we've sometimes seen courts issue orders which are directed at the employer. My colleague spoke at the outset about the organization's privileges and immunities, and this is an area where the Office of Legal Affairs must review the request and determine, to what extent to assert the organization's privileges and immunities with respect to the request, which is essentially to garnish assets of the organization. In that case, formal correspondence concerning the privileges and immunities will be sent to the permanent mission of the United Nations of the relevant member state. Nevertheless, while the organization may not be legally subject to the court order or the income withholding order, if it's accompanied by a final executable court order, this brings it under the staff rule and the bulletin, meaning the organization shall take the voluntary action to secure compliance with that order. If there's no court order accompanying the IWO, however, the organization won't be in a position to garnish wages without the staff member's consent. But again, the staff member will be notified under the administrative instruction on private legal obligations and if the staff member doesn't provide proof of the support, then the issue may result in disciplinary action. Now, back to the scenario of a final executable court order. If 30 days have passed and the staff member has not provided satisfactory proof of compliance or resolution, the administration will seek approval for deductions through its internal processes. And once approved, once payment instructions have been received from the recipient, the organization will make those payments directly in accordance with the staff member's payroll schedule, unless or until one of the following conditions occurs, and that might be cancellation of the order, cessation or expiration according to a date in the original court order, the staff member's separation from the organization, a modification order, or proof of amicable resolution, which renders the order moot. If we could go to the next slide. In addition to requests to secure compliance with support orders, the organization also often receives requests for information in connection with divorce or support proceedings. And privileges and immunities are implicated here as well, as the organization's records are protected, and generally the release of information requires the staff member's consent. However, in furtherance of cooperation with member states in the administration of justice, the bulletin allows the organization to provide relevant information in the specific context without the consent of the staff member. As with claims, the request must be routed to the responsible entity, and the staff member will be informed of the request and given a copy of the information that was shared with the requester. And next slide. Before I hand over to Cristiano and Dulcie in the pension fund, I wanted to just close with a couple bits of practical information that may be useful or relevant if you're representing an individual seeking child or family support involving a UN staff member. And that's first, as we mentioned, the United Nations Secretariat has tens of thousands of staff, and administration of these staff is decentralized and spread across the globe. So claims can only be dealt with by the entity which employs the staff member and can legally administer it. So it's strongly recommended that you try to identify and address correspondence to the relevant entity at the outset. So you may be able to get this information from your client, or you may be able to find information about the various entities and the structure so that you can find an appropriate contact point. And I've listed a couple of links here. Second, in order for the administration to correspond with you once you have the correct entity, we will need proof of legal representation, so please have that available. Third, I think as was mentioned earlier, our compensation framework is really quite complicated and differs significantly from the public and private sector. But there is information that's publicly available that may help you better understand the elements of compensation and entitlements to enable the courts to better understand the financial situation of the parties and arrive at an appropriate resolution. And so there's some links here for general information about our salaries and entitlement structure. And finally, on the subject of benefits and entitlements, there's a variety of options that are available to staff with dependents that they may be eligible for depending on their circumstances, including various allowances, education grants, insurance coverages, etc. But these must be claimed by the staff member, and the organization, is not able to accept an application for this from another recipient or pay it directly to the dependent. So this does require the cooperation of the staff member, and might require an order by the court for them to cooperate. So with that, I am done, and I would like to hand over to Dulcie and Cristiano.
Thank you, Erin. Good afternoon. I'm Dulcie Mopondera. I'm Chief of the Legal Office at the Pension Fund. I'm going to provide a brief overview of the Pension Fund and then hand over to Cristiano. So the Pension Fund is a defined benefit pension plan with 25 member organizations. Catherine mentioned the UN Common System. Those member organizations include the specialized agencies like WHO, the Food Agricultural Organization, FAO, ILO, the International Labour Organization, and of course the UN Secretariat. The Pension Fund was established in 1949, and it provides retirement, death, disability, spousal and child benefits for staff of the United Nations and the other member organizations. It is a subsidiary organ of the General Assembly, which means the General Assembly is our highest level governing body, which approves our budget, changes to our regulations, which determine the benefits that are payable by the fund. The pension fund is administered separately from the United Nations Secretariat. Hence, we have our own regime as far as benefits, as well as the types of claims that we deal with. It enjoys the same privileges and immunities as the United Nations. So again, the UN JSPF is immune from legal process. Pension fund benefit provisions are fully contained in our pension fund regulations and administrative rules. Next slide, please. So we will cover the spousal and child and secondary dependent benefits, our payment obligations, confidentiality, and the appeals process. I will hand over to Cristiano. Thank you.
Thank you very much, Dulcie. Good afternoon, everyone. My name is Cristiano Papile. I am a legal officer with the fund based in New York. And one of the large areas that I deal with in my day-to-day work are issues arising really around divorce, spousal benefits, the legal implications of that. And I'm going to talk a little bit about the major sort of topics that come up in that context, and especially in the context of divorce. Just as a bit of an overview in terms of to situate these benefits. First of all, participation in the pension fund is compulsory for all staff members who have a contract of 6 months or more, unless expressly excluded in their employment contract. And this means that the vast majority of UN staff, virtually all UN staff, are participants in the pension fund. UN contractors and other personnel, non-staff personnel, would not be participants in the pension fund. As a general matter of administration, and also as required by Section B3 of our administrative rules, each participant is required to duly report their spouse or spouses and any children and secondary dependents to their employer. And then it is their employer that passes on that information to us at the fund, which then, of course, allows us to determine proper entitlements, both for the individual and upon their death to any survivors. Unlike a number of other pension plans, under the UNJSPF, a participant cannot designate a specific survivor. I will talk in the next slides a little bit about how we determine who the survivor or survivors are. But it is important to keep in mind that, and this is important especially in the context of divorce, where a party might want to be specifically designated as a survivor in the case of the individual's death, that is not a facility that's available under our regulations. And by the same token, a court determining that a particular individual should be deemed to be our participant's survivor would not necessarily work unless, of course, that survivor were already entitled under the provisions of our regulations and rules. And so I think the main takeaway here is that spousal benefits are dependent on the conditions for payment under the UNJSPF regulations being met, and they are payable upon the death of the retiree. Next slide, please. So in general, we have 3 different types of spousal benefits, and all 3 of these only become payable once the main retiree is deceased. The first one is described under Articles 34 and 35 of our regulations, and that is the widow's or widower's benefit. This is a benefit that is paid at no additional cost to the retiree. In other words, whether you are married or unmarried in the fund, you still pay the same percentage of your remuneration as contributions to the fund. And once you retire, your own benefit will be the same whether you have a prospective survivor or not. So in that sense, this is a benefit that comes at no additional cost to the retiree. It is a benefit that is automatically payable to a spouse who was married to the retiree at the time of the retiree's separation from service and who remained married to the retiree until the retiree died. Or in the case of a retiree who dies in active service, it's payable to the spouse who was married to the retiree at the time of his or her death in service. Article 35 bis of our regulations covers what we call the divorced surviving spouse's benefit. This is a benefit who is available in certain conditions that I will discuss in the next slide to a divorced surviving spouse of a retiree. Similarly to the benefit that I was describing a moment ago under Articles 34-35, the divorced surviving spouse's benefit is also paid at no additional cost to the retiree. And as I said, it's automatically payable to a former spouse who meets the eligibility conditions that I will discuss in a moment. And finally, the third type of spousal benefit that we provide is described under Article 35 ter, and that is a benefit that may become payable to a spouse whom the participant marries after having separated from service. That does come at a cost. It is an optional purchase that the retiree can make, which results in a reduction, in a permanent reduction to the retiree's own benefit. So I'm not going to talk in more detail about that specific benefit, but it is available to individuals who marry after separation from service and wish to essentially purchase an annuity for the benefit of their new spouse. The fund also pays child benefits for children who are under the age of 21 and for disabled children beyond the age of 21 and for secondary dependents who are parents or disabled brothers or sisters. But the conditions for payment around those benefits are fairly specific, and they're covered in Articles 36 and 37 of our regulations. I don't intend to go into any detail regarding those benefits. Again, it's really a matter of the entitlement either being met or not met under the fund's regulations. It does depend on things like whether the retiree has elected a full retirement benefit as opposed to, for instance, an early retirement benefit, which has implications in terms of whether and when these benefits become payable. But unlike the spousal benefits, the child benefit is payable also while the retiree is alive. So on this slide, I'm going to talk a little bit more about Article 35 bis, the divorced surviving spouse's benefit that I was mentioning earlier. All of those spousal benefits that I talked about are periodic benefits that are payable for life. So on a monthly basis for the life of the spouse or divorced spouse who is entitled to them. In the case of a divorced surviving spouse, he or she will receive the benefit if these four conditions are met. The first condition is that the parties were married for at least 10 years, during which contributions were paid to the fund. In other words, the participant was in active pay and contributory status, or during which the participant separated on disability. So that's the first condition that we look for. The second condition is that the participant's death must have occurred within 15 years of the divorce becoming final. Otherwise, this condition is not met unless at the time of death, the participant was under a legal obligation to pay maintenance to the former spouse. So when the participant dies and we're examining whether these four conditions are met, one of the things we look at is we look at the time elapsed from the time when the divorce became final until the time of the participant's death. If that's within 15 years, this condition's met. If not, we dig deeper and we have to establish, we essentially require proof that at the time of death, the retiree was under an obligation to pay maintenance to the former spouse. Provided that that condition is met, then this requirement would be met. And usually that is established through either a copy of the divorce order or the settlement agreement incorporated into the divorce order that establishes that maintenance obligation. And depending on the time that has elapsed, depending on the circumstances of the case, we may end up requesting additional evidence that there had not been any modification to that support obligation in the intervening years. The third condition for payment is that the former spouse has reached the age of 40. Otherwise, we will start paying the benefit only once that spouse reaches the age of 40. And finally, the fourth condition is that the divorce settlement agreement does not contain an express renouncement of UNJSPF pension benefit entitlements. So again, when we're looking to see whether these four conditions are met, we either already have or we will be requested to be provided with a copy of the divorce settlement agreement, and we will review it to see whether there is any express renouncement of UNJSPF pension benefit entitlements specifically. And that has to be a very specific renouncement. It is not a general catch-all phrase that the parties renounce any claims on each other's pensions. We are really, in this context, we are looking for a very specific reference to the UNJSPF pension benefit entitlements of the retiree. And the reason for that is, again, in part, it goes back to the fact that this is a benefit that is not coming at an additional cost to the retiree, whereas in most cases, those disclaimers are really aimed at preventing a claim while the participant is alive. What we're looking at here is that, did the parties actually turn their minds to this specific possible benefit entitlement and jointly agree to renounce any possible entitlement to it? Next slide, please. So as I mentioned, spousal benefits, including this divorced surviving spouse's benefit, comes at no additional cost. So why, you might wonder, why would anybody want to renounce this possible entitlement to a benefit? The reason for that is that in the event that the participant remarries, so divorces and then marries a new spouse before they separate from service, and they remain married to that new spouse until they die, then that new spouse, you'll recall from my earlier slide, becomes automatically entitled to a spousal benefit under Articles 34 and 35 of our regulations. And in those cases, if we have both a current spouse entitled under Articles 34 or 35 and a former spouse entitled under Article 35 bis, then we don't pay a double benefit. What we do is we look at the total amount of the widow's or widower's benefit, and then we split it between the current and the former spouse, and we do that in proportion to the duration of their marriages to the participant. And so you can envisage a scenario where perhaps a participant has been married to their first spouse for quite a number of years. They divorce, they may intend to, or they might imagine that they might remarry, but they might be further on in their career at that point. And if you end up having a situation where a participant's been married to their first spouse for, say, 30 years and to their second spouse for 5 years, then if you have two benefits, a portion in proportion to those marriages, the new spouse is going to have a relatively very small benefit. So it is really in that context that the participant might want to negotiate that kind of a renouncement of benefit entitlements with the spouse that they are divorcing. And that's why we really look for a very specific renouncement to be included in the divorce documents and not just a general renouncement of claims to pensions. Next slide, please. That concludes the section of my discussion on benefits that automatically arise by virtue of a spousal relationship or a divorced spouse. The next couple of slides, I'm going to discuss payment obligations. And this really is essentially in parallel to what Aaron was describing that the UN does in relation to active staff members. But what I'm going to discuss here is what the pension fund can do in relation to staff members who have retired. First of all, as a matter of principle and as explicitly stated in Article 45 of our regulations, our participants are not allowed to assign their rights under the UNJSPF regulations. So they cannot use their pensions as collateral. They cannot draw on their pensions and assign them to any other individual other than themselves. However, under Article 45, we have the facility to deduct a portion of a retiree's monthly benefit, so that's a benefit in payment, to satisfy a legal obligation arising from a marital or parental relationship. And of course, what that means is things like child support, alimony, division of pension as a marital asset. We've had even a case where we had a mortgage obligation that was clearly, based on the documentation we received, clearly tied up. It was essentially a legal obligation that arose from a marital relationship. In order to apply that deduction under Article 45, we need evidence that the obligation is established by a final and executable court order or by a settlement agreement that has been incorporated into a divorce or other court order. In New York State, we often receive qualified domestic relations orders, quadros. It's not, strictly speaking, necessary for us to have a quadro. We can use as a basis for us to consider applying Article 45 any court order, provided that it is final and executable. That doesn't mean that you can't get a quadro. And in fact, we review them quite routinely. And if duly entered and provided to us, they can absolutely form the basis for a deduction under Article 45. Article 45, the deduction under Article 45, can only be applied once a participant separates from service. And that is because we don't actually, the participant has no entitlement to any benefit until they actually separate from service. I should say also, and you know, this is the same idea that came up earlier with the discussion around our privileges and immunities, is that we are not routinely simply taking the court order and applying it. The court order really forms a basis for us to consider whether under Article 45, we can effect this deduction. But we are under no obligation to implement the court order, although we do indeed seek to give effect and to assist in satisfying the obligations that a retiree may have. Next slide, please. Procedurally, how does this work? If you have a client who wants to request a split payment from the fund, how does it work? First of all, the request can be made by either party. So either the retiree or the former spouse can approach the fund and request us to consider implementing a deduction under Article 45. Aaron mentioned income withholding orders. And similarly to the UN, if we receive an income withholding order, that alone will not necessarily be sufficient for us to effect a deduction under Article 45. If it's accompanied by a copy of the underlying court order establishing the obligation, then that underlying court order can serve as a basis. And so typically, if we do receive an income withholding order, we do provide information as to what we need to be provided with. And then once we receive the court order, we go from there. Once we have a court order, we seek comments from our participant retiree before making any decision under Article 45. Depending on the comments, we may need to go back and forth a few times. As you can imagine, given our participant population being spread around the world, sometimes there are issues that arise in terms of parties having obtained court orders in different jurisdictions. And so there are cases that are a little bit more complex where we have to go into some level of scrutiny and maybe need a little bit more back and forth. Once we are satisfied that we have enough information to proceed, it's important to note that Article 45 can only be applied to periodic benefits and payment, that is, monthly retirement benefits. In some cases, a participant has the option to fully or partially commute a benefit into a lump sum, and we do not have any mechanism whereby we can deduct a portion of that lump sum and pay it to a former spouse. Also, we typically cap the maximum deduction of the monthly benefit to 50% of the gross benefit. If we do make a decision to apply Article 45, we apply it on a prospective basis only. As with the UN, and as Aaron was mentioned earlier, we don't have a mechanism to recover arrears unless, and in some limited cases, we have situations where the court will order liquidation of arrears through, again, a monthly payment obligation. If it's expressed in those terms, then we do have some level of discretion to decide whether we can effect that deduction under Article 45. But we do not have a mechanism to simply satisfy any arrears that are expressed as a lump sum obligation. And finally, once Article 45 is applied, that deduction is normally irrevocable unless there is a new court order that modifies or terminates it. Otherwise, the deduction will terminate upon the death of one of the two parties. Moving on to a couple of administrative or more practical matters. First of all, on confidentiality. Under our administrative rule B4, the fund cannot disclose information about a participant without the participant's written consent. The only exception to this is if we receive a court order or a request from a judicial or civil authority in the context of a divorce or family maintenance obligations. If we receive that type of a court order or request, then we are required first to notify the participant, who has 30 days to respond and supply the information. If after 30 days the participant fails to do so, then we are permitted to provide first the amount of benefits received and in payment for the beneficiary, second, accrued entitlements for an active participant, and third, the address of the beneficiary. So we're quite constrained in terms of the information that we can provide and the authorization that we need before we are able to provide it. And finally, my last slide discusses briefly the appeals process in the case that either our participant or the interested party, for example, the spouse, is dissatisfied with whatever decision the fund has made, whether this is in relation, for instance, to eligibility for a spousal benefit, a divorced surviving spouse's benefit, or for that matter, in respect of a deduction under Article 45 of the regulations. So requests for review or appeals are governed by Article 48 of the fund's regulations, and under Section K of our administrative rules. We have links to the regulations and rules at the end of the presentation, so you can look at those. Essentially, a participant or a beneficiary can challenge a decision on the application of the fund's regulations and rules that affect their UNJSPF benefit entitlements. In the context that we're discussing, as I said, that's going to be around eligibility for a spousal benefit, or perhaps around a decision that the fund has made in relation to a deduction from a benefit. The procedure is slightly different if you are dealing with an active contributing staff member or a retiree or other beneficiary, and you'll see from the chart at the bottom of the slide. For active participants, there are effectively 3 levels of review. The first level of review is, it's noted there as SPC, that stands for Staff Pension Committee. That is a committee that is particular to each member organization in the pension fund, and it would be the first instance review for active participants. Thereafter, if the appellant is dissatisfied with the decision of the SPC, they can appeal to a body known as the Standing Committee of the Pension Board, and thereafter they would have a final level of appeal to the United Nations Appeals Tribunal. For retirees and other beneficiaries, it's only a 2-level of appeal, with the first level going directly to the Standing Committee of the Pension Board and the final level going to the UN Appeals Tribunal. Now, typically, the appeals process would really only be initiated after some degree of correspondence and back and forth between the pension fund and the interested party or parties. And so this is really just to give you an overview of what the process looks like. But if you were ever to find yourself, or if one of your clients were ever to find themselves in a situation where their case was, where the next step would be an appeal, they would at that time receive a letter from the pension fund setting out the decision in respect of which they might wish to appeal, and providing detailed instructions on the deadline for the appeal, the mechanism for submitting the appeal, and the body to which the appeal would need to be submitted. So if you ever found yourself in that situation, you would have that additional information provided to your client. That is the end of my slides. I think the next slide we have links to various resources. And with that, I will hand it back over to Melissa, and I think we'll be taking your questions at this point. Thank you.
Absolutely. Thank you so much. That's a lot of information that was very well organized. There are a few questions, so those who are still logged in, please post your questions. I'm going to take them in chronological order. The first question was directed to Cristiano. It was, I think, when slide 26 was up, just in case we need to reference back. Is the implication that children over 21 do not get benefits in the case of, say, a death, for example? Can you please speak to this a little?
Certainly. So the way it works for child benefits is that in all circumstances, a child benefit is only payable until the child reaches the age of 21. The only circumstance in which a child benefit would be payable beyond the age of 21 is in the case of a child who has been certified as being disabled by the staff pension committee of the member organization for which the parent had worked. So yes, in all cases, including in the case of death of the staff member, of the participant, the child benefit, unless the child is disabled, will stop at age 21. The only thing that will change if the participant is deceased is that we then look to see whether there is any other parent who is essentially able to support the child. And in cases where neither parent is able to support the child, so perhaps in the case we call these orphans benefits, but it could also be that the other parent is not employed or is not able to support the child, then in those cases, the child benefit is increased. And there is a formula for that in our regulations, but there are circumstances where the amount of the child benefit would be increased upon the death of the parent. But it still would not be paid beyond the age of 21 unless the child were certified as disabled.
Okay. So I'm not sure who might want to answer this question, but in the case of a fee dispute between an attorney and their client, where the client is a UN employee, can the UN employee assert any sort of immunity from mandatory fee arbitration or civil litigation seeking the attorney fee award?
I think so.
Does anyone want to take that?
I can take that one.
Catherine, go ahead.
Thank you. Sorry, technical issues. So the issue here is that the privileges and immunities there are two sets of privileges and immunities. There are and I'll just say P&I for short. There's the P&I, the and I for the organization, which is not relevant. The staff members have privileges and immunities. It's granted to officials for the implementation of their official functions, not to avoid their private legal obligations. So if there is an order against the staff member to pay certain fees, then that would be a private legal obligation of that staff member, and they would not be able to avoid payment of those fees. I don't know if that helps.
Yes, thank you. Okay, another question. There was a reference to quadros, qualified domestic relations orders. Does the UN review draft quadros? And if so, how long does that process take? And is there a sample document to ensure that the draft quadro satisfies your regulations? Cristiano.
Yeah, I can take that question. So we do review draft quadros. We don't approve them, so to speak, because again, we're not subject to the jurisdiction of that court, but we will certainly review the quadro and we will provide comments on it. Typically those are coming to me and I typically try to turn them around within a couple of days. In terms of, I think there was a second part of the question. Can you just remind me, Melissa? I don't see it anymore.
Oops, do you have sample documents?
Oh, sample documents. Yeah, thank you. No, we don't have sample documents. But, you know, I would say we've received, I've seen quadros that they're all similar and they're all different. And ultimately, I think the important thing to keep in mind is that in terms of it being acceptable for the fund to apply a deduction under Article 45, the main thing is it really simply has to clearly establish the obligation and then be validly issued by a court. One thing I will note in the context of quadros that are being issued while an individual is in active service is that typically in New York, it's known as the Majauskas formula. Other jurisdictions have different similar formulas. Typically, there's something included where the pension is aimed to be split. The marital portion of the pension is split according to a formula that essentially says you take the number of months that the parties were married during which they were contributing to the fund, divide that by the total length of participation in the fund, divide that by 2, and that gives you the portion of the pension benefit to which the former spouse is entitled. The pension fund will not perform that calculation. So it really is important for the parties, and that's typically what you're including in a quadro, is you're including that formula. And the comment that I will routinely go back with when I see that is, this is all well and good, and we appreciate that you're not able to specify the percentage now because the participant is still in active service. However, be aware that once the participant separates and you want us to apply this quadro, you will need to tell us what the percentage is. And if the parties at that time disagree as to what the percentage is, then you will need to sort that out amongst yourselves. The fund will not make that calculation. The other important thing to keep in mind when you're drafting a quadro is, as I mentioned in one of my slides, sometimes we have situations where the court order purports to require the fund or require the beneficiary, the participant, to designate the former spouse as the survivor or as being entitled to the divorced surviving spouse's benefit. And again, that's clearly not a renouncement. However, that spouse's entitlement will only be there if, when the participant dies and we're reviewing our regulations, that spouse meets those conditions for payment of the benefit. The inclusion of that requirement in the quadro would not alone be sufficient to establish that entitlement.
Okay. I have a question that indicates that this lawyer has a child support case against a current UN employee at the Lima, Peru office. The court has ruled in favor of the person who's seeking child support and ordered the UN employee's wages garnished. So based on this presentation, should this lawyer just contact the Peru office or the New York office with this court order?
I can take that. It's really best to try to direct to the local office that administers the staff member. And there are some, situations where people are on loan or administration might be done by a service center, which isn't located in the area. But I think the first port of call should always be the entity or the office where you believe that the staff member is based. And if you direct to the head of entity or more specifically to the chief or, director of human resources, they can then try to route it appropriately. And I would just note that, when you're sending this kind of information, it's important to provide the court order, but also if you can provide the name and the date of birth of the staff member, that helps. I mean, we have a lot of duplicative names. And also if you happen to have the index number, which is the number issued by the organization for the staff member, that helps us, whoever is receiving the query, identify the individual or the organization that would be the correct organization to forward it to. I see Catherine wants to add something.
Yes.
Thank you, if I may. And only really just an observation. I was looking online when I saw the question in the chat, just to see which UN offices are actually in Lima, in Peru. And there are UN offices. There are the offices of the UN Secretariat. There are offices of funds and programs, for example, UNDP. There are also specialized agencies as UNESCO, and then there are other parts of the UN, which is the High Commissioner for Human Rights. So the key, as Aaron had indicated in her presentation, is to identify the organization the staff member works for to make sure you're sending it to the right organization. And that was the minister. Thank you.
Very complicated. The next question is if you're filing a divorce lawsuit or a child custody lawsuit and the court issues a summons that needs to be served on the other party, and that party is a UN employee, could there be immunity invoked against that? And that's like a whole separate webinar in and of itself, I'm sure. Would anyone try to field this, or is this a for another day type of question?
I mean, in general terms, under the staff regulations and rules, every staff member has a letter of appointment with the organization, and as part of that letter of appointment, they are subject to the United Nations staff regulations and rules. And as we indicated earlier in the presentation, there is a staff rule 1.2b, which indicates or states that staff members must comply with local laws and honor their private legal obligations, including obligations to honor orders of competent courts and so forth. Staff members need to comply with their obligations, but it might be a little bit maybe outside the scope of this session. But I imagine there are ways to.
Right, there are a whole host of different immunities, not just for UN, potentially for UN individuals, but a whole host of others as well. I agree. But very important question. Another person asked, in New York family court child support cases, many of their orders of support are paid through the support collection unit, which enforces the order. If there are child support arrears, that support collection unit will issue payroll deduction orders of up to 60% of pay in order to collect their arrears. If that is sent to the UN for payroll deduction, will it be honored, or will arrears be collected only if the underlying court order states the specific amount to be paid? And I also saw one slide that implied that there might be a limit in how much might be deducted. Anyone want to field this? 60% of pay to be collected. Erin.
I'll start, and I think then Cristiano might want to jump in. There, again, this goes to the distinction between what's allowable under the Bulletin on Family and Child Support specifically, and what the process is for the administrative instruction on private legal obligations. And we will only garnish on the basis of a final judicial court order that has established the amount of the child support with a periodic payment. And if there is a specific periodic amount ordered by the court for the arrears, liquidation of the arrears, then we can implement that. But I don't think we would be in the position if there was just the, I haven't specifically seen this type of issuance, but unless it was supported by an underlying court order ordering that liquidation on a monthly basis, we would have to treat it under the instruction as a private legal obligation and, you know, request the staff member to comply, but we wouldn't make the deductions. And I think the part about the 50% was in the pension. We don't currently have a max for salary. The staff rules provide that we shall implement in accordance with the court order. So it really is the responsibility of the staff member or of their, you know, ex-spouse to make the case about what the appropriate amount of support is. And again, we're a global organization, perhaps more than, you know, a local employer. We do have staff members who have families, multiple families spread across the globe. There are situations where there may be multiple court orders coming from different jurisdictions. Again, it's the staff member's responsibility to make that case to the different jurisdictions. You know, we're not authorized to kind of pick and choose between the court orders or give priority to, you know, one jurisdiction over the other with respect to the child support that may be owed to different families of the staff member.
That's an excellent point, because I do see cases where the rules are different, the laws are different in different jurisdictions. So one country may issue a child support order, a US court may also issue a child support order. Both of them did so under the law of their jurisdiction, and they're both valid orders in those countries. And maybe they're going to be fought on jurisdictional basis. Maybe they're both going to lose. So there are going to exist two orders, and that could be quite complicated because they could be very different amounts if they're presented to an employer like the United Nations. Cristiano, did you have anything to add?
Yeah, I will. Thank you, Melissa. So I think in terms of the documentary requirements, the pension fund is quite aligned with what Erin was describing as being the process at the UN. So we also, the order from the child support or from the support enforcement unit would not by itself be sufficient. We would need an actual court order from a judicial authority converting that arrears into an ongoing monthly payment obligation. We would cap the deduction to 50% of the gross monthly benefit of the retiree. And yes, what you were also mentioning about international sort of jurisdictions is it's an interesting topic. And this is why sometimes if we do have competing, at least I can speak for the pension fund, if we have competing or different court orders from different jurisdictions, it may not be as straightforward a process to decide if and how to apply a deduction under Article 45 of our regulations.
There was a question that Richard and Erin already started answering in the chat. I just wanted to put it out there in case there was any additional thoughts. The pay structure is very interesting for international organization employees. I'm usually in DC, so I deal a lot with the World Bank. There are a lot of benefits. There are a lot of things they don't necessarily have to pay, and so one attendee was asking about calculating child support. In other words, calculating what an employee's income would actually be for purposes of calculating child support, and what things or benefits might exist for your employees that we as lawyers might decide to add to a person's income to increase their income for purposes of calculating child support. I don't know if anyone had any additional thoughts. Erin did add in that staff members who are U.S. citizens typically are responsible for making Social Security contributions under the framework for self-employment.
And I would just add in the presentation, which you'll get on the slide, I think it was the practical information slide that I had included in my portion of the presentation. There's a couple links to publicly available information about our compensation structure, because it is very complicated. As you know, probably know, most UN staff are exempt from taxes in some respect. The US has a different arrangement than other countries. So there is this thing called staff assessment, which is quite a large portion, but this is not money that's ever available to the staff. This is a way that the different member states are satisfying part of their financial obligations to the organization through, proportions of through a kind of earmarked amount linked to their staff. It's very complicated, but that's never money that the staff get, and it's not, being paid to a local tax authority. The other thing, for a professional international staff, there is a post adjustment, which is under the Noble Mayor principle, which is supposed to equalize, buying power for staff across the globe. So it doesn't matter if you're in New York or Nairobi, you should be, basically equally compensated. That is tagged to, I believe, the comparator is still the US federal government. And so that is a portion that will fluctuate depending on what the current post adjustment scales are. So that is money that staff get in addition to whatever their salary is. So, there's information about all of these elements that is available. So we would encourage, attorneys to really familiarize themselves with these elements. And then, all of this information is very clearly delineated in the staff members' payroll statements. And so it will show the amount of deductions that are being made. As Christiana said, basically almost every staff member is a mandatory participant in the pension fund. So it will show the mandatory deductions that are going to the pension fund, every month. It will show if they're enrolled in health insurance, the portion of the health insurance that comes out of the staff member's salary, and the portion that is, subsidized by the organization. So these are very detailed pay statements. And if you combine that with the information about all of the elements of entitlements, I think you can get a better picture. We have seen cases where this has gone drastically wrong, where somebody didn't, the court misunderstood and either thought that the staff member was making, much less than they were, and that resulted in a very low support order, or where they thought the staff member was taking home far more than they actually were, which resulted in unsustainable so again, as attorneys, this is really a place where you can, if you're representing the UN staff, you can really advocate for them to make sure that their compensation is understood. And if you're representing a client, it helps you to get a better understanding of what the actual compensation structure is, so that what you could advocate for your client to receive. So I'll stop talking now.
If I'm representing the non-employee spouse and I request the UN employee spouse in a formal discovery process in the court for copies of their pay statements and they don't provide them, can I send a subpoena to whatever their office is to secure copies of their pay statements?
I think Francesca or Catherine may want to add, but because of the privileges and immunities, we would not be legally bound to respond to that subpoena. However, if it is a request from the court for information, or if it's demonstrated that this is a valid request for specific information in the context of this proceeding, we may be able to voluntarily provide that information. Again, if the staff member consents, we can absolutely provide the information. But if it's established that this is necessary information for the proceeding, and particularly if the request comes from the court, we can voluntarily, without waiver of privileges and immunities, provide information that's within our control.
Another question that was posted: if the pension is in pay status and the former staff member dies, does the alternate payee's benefit terminate upon the death of the former staff member?
I can take that. Short answer, yes. Longer answer is that the way to conceptualize what we're doing under Article 45 of our regulations is that it is simply a payment facility. It's a deduction. It's like a standing order with your bank to send a certain amount of money to somebody at the end of every month. We are not establishing any separate benefit entitlement for that divorced spouse. That spouse has no rights directly vis-a-vis the fund. The only thing that we've done when we apply Article 45 is we have agreed to pay a certain percentage of the main benefit to a different bank account, to a different individual, because of that underlying obligation by the retiree. As a result of that, if either of the two parties dies, whether it is the retiree or the former spouse, there's no more deduction to be made or to be paid. And so that's why it comes to an end immediately at that time. What then may become payable is what I discussed earlier, the divorced surviving spouse's benefit under Article 35 bis. And that's a survivor's benefit. It is payable if that divorced spouse meets those 4 conditions for eligibility. And if that benefit is payable, then it is payable from the first day of the first month following the retiree's death. And it is then payable to that divorced spouse for life. Now, what's interesting sometimes for parties in these situations to learn is that the amount of the benefit paid as a divorced surviving spouse's benefit, if it is payable, may have no relationship, no connection whatsoever to the amount of the payment that spouse was receiving as a deduction from the main benefit. A survivor's benefit is typically 50% of the main benefit entitlement. So you have situations where perhaps the participant, the retiree, is under an obligation to pay, say, 25% of their gross monthly benefit to their former spouse. Then they die, that spouse becomes entitled to a divorced surviving spouse's benefit, and it's now going to receive a sum that is roughly equivalent to 50% of what the main retiree's benefit was. They're two separate concepts, and really the important thing for the deduction under Article 45 to be kept in mind is really this is just a payment facility. The underlying benefit is always and only to the main retiree until he or she dies, at which point we assess whether any survivor's benefit may be payable.
The last question that's in the Q&A is actually more of a question for everyone who attended today, whether or not there's some law that might allow for non-cash compensation to increase income for child support purposes. So if anyone is inclined to try to answer that, they can post something in the chat or in the Q&A, but I don't believe that's necessarily a question for our amazing panelists today. Any other questions before we wrap up? I'm not seeing any more posted. Any remaining thoughts from any of our United Nations staff that joined us today? Catherine.
Thank you, Melissa. And perhaps not any more thoughts, but just a thank you to the participants who actually asked the questions and listening to our presentation today. There was a lot of information, as I said, and hopefully the resources will provide. There'll be good resources for participants to actually look to in future, and just keep looking online, because sometimes various regulations and rules are updated, so making sure that they have the latest at all times. Thank you. Might have other panel members wish to add anything with your permission.
Of course. Anyone else? Well, failing that, I want to thank everyone for attending today. I want to thank our amazing panelists. I'm really grateful for all of your hard work. I know that your jobs are extraordinarily busy, so this was a huge chunk of time devoted to sharing this information. Richard and I would like to encourage everyone to join the New York State Bar Association's International Section. Our Family Law Committee is small, but does some amazing programming. So please, Cara put the link in the chat if you're interested. Our next big program is on Tuesday, May 2nd at Blank Rome in New York. We are hosting a full day of in-person programming with CLE credit on advanced issues in Hague Abduction Convention cases. So thank you again, and I hope everyone has a wonderful rest of their day. Thank you.